Legislative drafting is not instinctively where we go when we start talking about the weapons in the lawyer's arsenal, particularly in pursuit of social justice objectives. As a nation, I think we've been drawn to landmark cases like Brown versus Board of Education and Gideon versus Wainwright. And for those of us who were in law school during that Warren Court era, you were tempted to think that it was going to go on endlessly thereafter, and of course it hasn't. So there's a tendency on our part to think that law reform or impact litigation is the way to go when you're seeking social change. I think particularly in the last several decades, the real battle has been in legislative forums, and particularly in state legislative forums. Increasingly, with deadlock in Congress, we're drawn toward more and more fighting battles in state legislatures and even to some extent municipalities. So there's this tendency of all of us, lawyer and non-lawyer alike, to think in terms of law reform litigation before we start thinking about legislation. We're also, as lawyers, encouraged to think mostly about litigation because what do we have law students read in law school? Relentlessly, appellate judicial opinions. You could graduate law school and justifiably think that most of the meaningful law in our society is written by appellate judges because that's mostly what you've read. In fact, of course, a vast body of law is written directly by federal and state legislative bodies. And I would suggest an even vaster body of important law is written by administrative agencies in the form of rules and regulations. So why do we need to think about legislation and, for that matter, regulations? Because they're important, because they're a major part of what impacts our clients' needs, and because we can make change through those procedures in different ways and using different strategies that might come into play in a litigation context. Well, every drafting project starts out as a problem that adversely impacts people. And when you're trying to help a legislative drafter get off the dime and start drafting, one of the most useful things you can do is to give practical information about the dimensions of the problem. I mean, newspaper articles and magazine articles and television broadcasts are all packed with information about the nature of the problem. So giving some real-world sense of what's at issue is a good start. You can certainly go farther, and those who have had some legal training can get into trying to identify the statutes that might be the source of the problem, or perhaps an unfavorable attorney general's opinion or agency regulation. And all of those things, if they can be identified and shipped on over to a drafter, would be all to the good. And then, of course, it helps to link drafters with clients who've faced the real-world problem. And in addition, it helps to link drafters with a person that we call, in our practice, a resource person. You know, the client knows why it's a problem, but the client might not necessarily have a sense of what's the best solution. A resource person might not be immediately impacted by the problem, but might have a depth of knowledge and a sense of what could be done to solve it that is very useful. So we try to encourage students who are working in our classes to have both a client at hand and a resource person, and to learn from both of those perspectives. Deciding how broad or narrow to make a bill is one of those judgment calls that won't ever be guided, I think, by bright line wisdom. There are so many factors in play. It's a dynamic system. There are general laws that say perhaps very little about the substance that is being addressed, and that kick it over to administrative agencies to fill in the details. That could be a very wise strategy if you were dealing with a terribly challenging political problem that would have difficulty passing the legislature if it were dealt with in detail, but that might get a much warmer reception in a favorable agency environment. And so on occasion, we've counseled students to stay at a level of generality with the statute and move into drafting an accompanying legislative instrument, regulatory instrument to go with the legislation. So that's one approach. The scope that will be applied to the law by the courts is another dimension. We're all familiar with the concept that criminal laws and punitive laws should be narrowly construed, and there are a number of other laws, a lot of them having to do with sunshine issues like open meetings and public records, that our statutes call to be broadly or liberally interpreted. That's a good piece of guidance, I think, for legislatures to give to the courts, and it's important particularly when you're dealing with issues that involve the rights of the public, like the open meetings and the Public Records Act.